My father built our house with his own two hands back in 1979, mixing concrete on weekends after his shifts at the plant. And I never once imagined that the same house would become the battlefield where my brother and sister tried to destroy him. I'm Sarah, I'm 34, and until 8 months ago I believed my family was ordinary. Not perfect, but ordinary. We fought over Thanksgiving seating and who forgot whose birthday, the normal stuff. I had no idea what my siblings were capable of until I watched them stand in a courtroom and swear under oath that our father could no longer think for himself. My dad's name is Frank. He's 71 years old, a retired machinist with hands like leather and a memory sharper than mine. 3 years ago he was diagnosed with early-stage Parkinson's, which slowed his hands and sometimes his speech but never his mind. He still did the crossword every morning in pen because he said pencil was for people who doubted themselves. I'm a nurse. I work at a hospital 20 minutes from his house, and after my mother passed 6 years ago I started stopping by most evenings to check on him, cook dinner, sit with him while he watched his westerns. It wasn't a burden. It was just what you do for the parent who raised you when your marriage fell apart and you had nowhere else to land. My older brother Mark lives 2 hours away and calls maybe once a month. He runs a construction supply business that's been bleeding money since the pandemic, though he'd never admit that to your face. My younger sister Denise lives across town, married to a man named Chris who flips cars for a living, and she has expensive taste that her income has never quite caught up to. I tell you all this because you need to understand the players before I tell you what they did. It started small, the way these things always do. Mark started coming around more often, which should have felt nice, except every visit ended with him asking Dad questions that felt less like conversation and more like an inventory. How much is left in the retirement account? Has he thought about what happens to the house? Does he still have that life insurance policy from the plant? I noticed it, but I told myself I was being paranoid. Mark was my brother. Families ask about money sometimes. That's not a crime. Denise started showing up too, bringing takeout, sitting with Dad for an hour, taking selfies with him for her social media, captioned things like cherishing every moment with my sweet dad. The captions bothered me more than I could explain at the time because they read like something written for an audience, not for him. Then one Tuesday evening in March, I got a call from Dad's neighbor, Mrs. Alvarez, who told me a man in a suit had come to the house that afternoon while I was at work and that Dad seemed confused about who he was. I called Dad immediately. He answered on the second ring, sounding completely normal, and told me some fellow came by asking questions for what he called a wellness assessment that Mark had scheduled for him. Dad said he thought it was strange, but Mark told him it was just a routine thing the insurance company required. I didn't like it at all. I called Mark that night and asked him directly what wellness assessment he was talking about. He got defensive immediately, told me I was overreacting, said it was just a doctor doing a checkup because he was worried about Dad living alone. I asked him why he hadn't told me since I was the one who saw Dad almost every single day. He said he didn't think it was a big deal. It was a big deal, I just didn't know how big yet. 2 weeks later, Denise invited me to what she called a family meeting at her house, the kind of phrase that should have made every alarm in my body go off. But I went anyway because I still believed foolishly that we were a family that talked things through. When I walked into her living room, Mark was already there, along with a man in a gray suit I didn't recognize, sitting stiffly on Denise's good couch with a leather folder in his lap. Denise introduced him as Dr. Reeves, a geriatric care consultant who had evaluated Dad the week before. I asked why nobody told me about this evaluation. Denise said they didn't want to worry me until they had answers. Dr. Reeves opened his folder and started talking about cognitive decline, memory lapses, difficulty with complex decision-making, using words that sounded clinical but didn't match the father I saw every single evening of my life. I asked him what specific tests he ran. He mentioned something called a mini mental status exam, gave a vague description, and moved quickly past my question into a discussion about what he called next steps for Frank's protection. Something in my stomach turned cold. I've worked in healthcare for 12 years. I know what a real geriatric evaluation looks like, and this wasn't it. There was no documentation, no referral from Dad's actual physician, no chain of medical custody at all. Mark then said the words that changed everything. He said they wanted to file for guardianship to protect Dad's assets and make sure he was cared for properly, and that Dr. Reeves's evaluation would support the petition in court. I sat there in silence for a moment, trying to process what I was hearing. My brother and sister wanted a judge to strip our father of his legal rights, based on an evaluation from a man I had never heard of, conducted without informing me, the person who actually spent time with him every day. I asked the only question that mattered. I asked what would happen to the house and the accounts if the guardianship went through, and who would be named guardian. Denise looked at Mark. Mark looked at his folder. Neither of them answered me directly, which told me everything I needed to know. I left that meeting shaking. I sat in my car outside Denise's house for 20 minutes before I could even start the engine, replaying every visit, every phone call, every strange comment from the past few months, watching it all rearrange itself into a pattern I hadn't wanted to see. That night, I drove straight to Dad's house instead of going home. He was sitting in his recliner watching an old John Wayne movie, and when I walked in he smiled the way he always did, completely unaware that his own children were building a legal case to take away his independence. I didn't tell him everything that night. I wasn't ready, and honestly I didn't fully understand what I was dealing with yet. But I sat with him longer than usual, and I watched him laugh at the movie, and I watched him do the crossword during commercials, filling in answers without hesitation, and I thought about the word incompetent and how obscene it felt sitting next to this man. Before I left, I asked him a few casual questions. What year did he retire? What was Mom's maiden name? What was the name of the dog we had when I was 12? He answered every single one correctly without pausing the way anyone would. I went home and I didn't sleep. I stayed up researching guardianship law until 3 a.m, learning terms I'd never needed to know before. Conservatorship, incapacity determination, letters of guardianship, power of attorney. I learned that once a guardianship is granted, the person loses the right to manage their own finances, make their own medical decisions, sometimes even the right to decide where they live. I also learned something that gave me a small, cold flicker of hope. Guardianship petitions require substantial evidence, and courts generally prefer to appoint guardians based on the recommendation of the person's own treating physician, not a stranger hired for a single visit. Dad's treating physician was Dr. Elaine Whitman, a woman who had been his doctor for almost 15 years, who knew his medical history better than anyone alive except maybe me. Mark and Denise hadn't used her. They'd used some outside consultant named Dr. Reeves that nobody in our family had ever met before March. That felt like a mistake on their part. I just didn't yet understand how big of a mistake or how deliberate their choice might have been. The next morning, I called Dr. Whitman's office and asked for an appointment, telling the receptionist it was urgent and it concerned a family matter regarding my father's care. She squeezed me in for that afternoon. I sat across from Dr. Whitman and told her everything. The strange visit from Dr. Reeves, the family meeting, the guardianship plan. She listened with her jaw getting tighter by the minute, and when I finished, she said something I will never forget. She said, "Sarah, I saw your father 6 weeks ago for his regular checkup. His cognitive function was completely normal. Nobody from any evaluation team ever contacted my office, requested his records, or asked me a single question about his mental state. That's not how a legitimate competency evaluation works." I asked her what she thought was going on. She chose her words carefully, the way doctors do when they're worried about liability, but she said enough. She said it sounded like someone was trying to build a paper trail to support a guardianship petition without going through proper channels, possibly because they knew a legitimate evaluation wouldn't support their claim. In other words, my brother and sister had gone shopping for a diagnosis, and when they couldn't get one from Dad's real doctor, they found someone willing to manufacture one. I asked Dr. Whitman if she would be willing to document her own assessment of Dad's competency, in case this went further. She agreed immediately and told me she'd also flag his chart so that any future guardianship evaluators would be required to contact her office. That was the first small piece of armor I managed to find. It would not be the last thing I needed. I left her office and called a lawyer that same afternoon, a woman named Patricia Coates who specialized in elder law and had a reputation in our area for being tough as nails. I told her the whole story in one long, breathless rush, and she stopped me halfway through to ask a question that made my blood run cold. She asked whether Dad had a power of attorney document on file, and if so, who held it. I didn't know. I had never asked. It had never occurred to me that this was something I needed to worry about, because until 3 weeks ago, my siblings had never given me a single reason to think they'd use something like that against him. I drove to Dad's house that same evening and asked him, as gently as I could, whether he had ever signed any power of attorney documents recently. He said no, not recently, though he vaguely remembered signing something for Mark a few months back that Mark said was for insurance purposes. My stomach dropped straight through the floor. I asked him if he still had a copy. He shuffled through his file cabinet, the same metal one he'd had since I was a kid, and after several minutes pulled out a folder. Inside was a document titled Durable Power of Attorney, dated 4 months earlier, naming Mark as Dad's agent with broad authority over his financial affairs. Dad stared at the paper like he was seeing it for the first time. He said Mark had brought it over one Sunday, told him it was standard paperwork everyone his age should have, and Dad, trusting his own son without question, signed it without reading every line. I felt sick. Not just because of what the document said, but because of how easy it had been. My father had spent his whole life working hard, being careful, being honest, and it took his own son 15 minutes and a folder of paperwork to gain legal control over everything he owned. I called Patricia Coates back that night and read her the document over the phone. She was quiet for a moment, then told me that a power of attorney is a serious tool, but it is not the same as guardianship, and it can be revoked by the person who granted it, as long as that person is still deemed competent. That was the key. As long as Dad was still considered competent, he could revoke the power of attorney himself, take back control, and shut this whole thing down before it went any further. The problem was obvious. Mark and Denise weren't just building a power of attorney case. They were actively working to have him declared incompetent, which would strip him of the ability to revoke anything at all. It was a race, and I hadn't even known we were running it until I was already behind. Patricia told me to bring Dad into her office the very next morning before anyone could stop us, so he could sign a formal revocation of the power of attorney and, more importantly, so she could personally assess his competency and document it herself as an attorney of record. I picked him up at 7 the next morning. He asked me what was going on, and for the first time I told him everything, sitting in my car in his driveway, watching his face shift from confusion to disbelief to something that looked like his heart breaking in real time. He didn't yell, he didn't cry, not right away. He just sat very still and said, "Mark wouldn't do that to me, Denise wouldn't do that to me." I had no good answer for him because I was asking myself the exact same question, and neither of us had an answer that made any sense. We drove to Patricia's office in silence. She met with him for over an hour, asking him questions about his finances, his medical history, current events, basic math, memory recall, the same kinds of questions any competency evaluation should include. Dad answered every single one clearly and correctly. Patricia drafted the revocation on the spot. Dad signed it with a steady hand, and Patricia notarized it herself and had it filed with the county recorder that same afternoon, along with a sworn statement from her own independent observations of his mental clarity. For the first time in weeks, I felt like we had solid ground under our feet. But Patricia warned me not to get comfortable. She said if Mark and Denise were serious about pursuing guardianship, revoking the power of attorney wouldn't necessarily stop them. A guardianship petition could still move forward through the courts, and if a judge sided with them based on manufactured medical evidence, the revocation itself could be challenged as something Dad wasn't competent to sign. It was a trap with no obvious exit. The very act of defending himself could be twisted into evidence against him if the people twisting it had enough nerve. I asked Patricia what our best move was. She said the strongest thing we could do was build an airtight record of Dad's competency, gather every witness who interacted with him regularly, get statements from his real doctor, and be ready to fight the guardianship petition head-on the moment it was filed. She also told me something that stuck with me for weeks afterward. She said, "In cases like this, the people trying to take control almost always overreach eventually. Greed makes people sloppy, watch for it." I didn't have to wait long to see what she meant. 3 days after we filed the revocation, Denise called me, and her voice was different than I'd ever heard it. Cold, clipped, almost robotic, like she was reading from a script someone else had written for her. She told me that Dad's revocation wouldn't hold up and that they had already started the guardianship process with a lawyer of their own. She said it was for his own good, that I was being selfish by interfering, and that I clearly didn't understand how much work it took to manage an aging parent's finances. I asked her point blank whether this was actually about Dad's well-being or about the house and the retirement account. There was a long silence on the other end of the phone, and then she hung up without answering. That silence told me more than any words could have. I called Mark next, hoping maybe he'd be more reasonable, hoping there was some part of my brother still in there who cared more about our father than about money. He answered, and before I could even finish my first sentence, he cut me off. He said Dad's Parkinson's was clearly affecting his brain, and that it was only a matter of time before he couldn't take care of himself at all, and that they were just getting ahead of it. He said the house was worth almost $400,000 now, and the retirement account had grown to nearly $200,000, and that money needed proper management, which apparently meant management by him. I asked him what proper management meant. He said things like consolidating assets, streamlining the estate, and avoiding unnecessary spending, phrases that sounded like they came straight out of some online guide for taking control of an elderly parent's finances rather than anything resembling genuine concern. I told him Dad wasn't a business account to consolidate. He told me I was being emotional and that emotional people shouldn't be involved in financial decisions. That was rich, coming from the brother who was 2 months behind on his own business loan payments. A fact I happened to know because Dad had mentioned, weeks earlier and without suspicion, that Mark had asked him for a temporary loan that never got mentioned again. I hung up the phone and sat in my kitchen for a long time, staring at nothing, trying to figure out how two people I grew up with, two people who used to build blanket forts with me in this exact house, had become people willing to lie about our father's mental capacity for money. I called Patricia and told her everything Mark had said. She asked if I had it in writing anywhere, texts, emails, voicemails. I didn't, not yet, but I promised her I would start documenting everything from that point forward, every call, every visit, every comment. That became my new life for the next several weeks. I started keeping a detailed log, dates and times and exact quotes whenever I could manage it, recording phone calls where legally allowed, saving every text message, taking photos of paperwork, building a case the way Patricia taught me to, brick by brick. I also started visiting Dad even more often, not just for comfort now, but as a witness to his own life. I brought a small notebook, and without making it feel clinical, I'd casually note the date and what we talked about, what he remembered, what current events he discussed, proof piling up in my kitchen drawer that he was exactly who he had always been. 2 weeks later, the guardianship petition was formally filed. I found out because Patricia called me the moment it hit the county docket, her voice tight with the kind of controlled anger that lawyers learn to keep locked down. The petition named Mark as proposed guardian of the person and Denise as proposed guardian of the estate, splitting responsibilities in a way that Patricia said was actually common in cases like this, because it made both siblings look less individually greedy to a judge while still giving them complete control between the two of them. Attached to the petition was Dr. Reeves's evaluation, the same vague, poorly documented assessment I'd seen weeks earlier at Denise's house, now dressed up in official legal language, claiming Dad suffered from progressive cognitive impairment consistent with early dementia complicated by Parkinson's-related decline. There was no mention of Dr. Whitman anywhere in the filing, no mention of his 15 years of consistent, thorough medical records showing normal cognitive function. It was as if they had deliberately built a case designed to avoid any doctor who actually knew him. Patricia said that omission alone would be a serious weakness for us to exploit in court, but she also warned me that judges see dozens of guardianship cases and sometimes err on the side of caution, meaning they'd rather grant a guardianship and be wrong than deny one and have something bad happen to a vulnerable elderly person. That meant we couldn't just poke holes in their case, we had to build something undeniable of our own. Patricia scheduled an independent competency evaluation for Dad, this time with a court-recognized geriatric psychiatrist named Dr. Aaron Incompetent, someone with an impeccable reputation and zero connection to either side of the family, someone whose findings would carry real weight in front of a judge. I drove Dad to that appointment myself, holding his hand in the waiting room while he filled out paperwork, watching the way his fingers trembled slightly from the Parkinson's but moved with complete purpose and clarity across every line. Dr. Incompetent spent almost 2 hours with him, running a full battery of cognitive tests, memory assessments, judgment scenarios, financial literacy questions. Afterward, he pulled me aside and told me off the record but with clear confidence that Dad's results were entirely consistent with normal aging and showed absolutely no signs of dementia or significant cognitive impairment. He said he'd have a full written report to Patricia within the week and that he intended to state clearly in his findings that Dad retained full capacity to manage his own personal and financial affairs. For the first time since this nightmare began, I let myself cry, not from sadness, but from something closer to relief mixed with exhaustion, sitting in my car outside Dr. Incompetent's office while Dad waited patiently in the passenger seat, unaware of just how much this appointment meant for both of us. But Patricia reminded me, gently but firmly, that we still had a hearing ahead of us, and that Mark and Denise weren't going to simply back down because our evidence was stronger. People who have already convinced themselves they're entitled to something rarely let go easily, no matter how thin their justification becomes. She was right, and what happened next proved just how far my siblings were willing to go. 3 weeks before the scheduled hearing, I got a call from Dad's bank. A woman from the fraud department, cautious and professional, asked if I was aware of a large withdrawal attempt from his retirement account that had been flagged for review. My heart stopped. I asked how much and who had attempted it. She told me it was a request for $85,000 submitted online using login credentials associated with the account, but flagged because the withdrawal destination was an account the bank system didn't recognize as previously linked to Dad's profile. I asked Dad immediately if he had requested any withdrawal. He looked at me, confused and a little frightened, and said absolutely not. He hadn't even logged into that account in months because he barely used online banking to begin with. That meant someone else had his login information, and there was only one person who had ever set up his online banking for him, back when the bank switched to a new digital system 2 years earlier and Dad, technologically hesitant, asked for help. It had been Mark. I called Patricia immediately, practically shouting into the phone, and she told me to stay calm and let the bank's fraud department handle their investigation while she filed an emergency motion with the court to freeze all activity on Dad's accounts pending the guardianship hearing. The judge granted the freeze within 2 days, an emergency protective order that locked down every account Dad owned, preventing anyone, including Mark, from moving another dollar until the case was resolved. I remember thinking, in a dark and exhausted moment, that if my brother had actually managed to pull off that withdrawal, none of us would have ever known where the money went. It could have vanished into some account under a different name, disguised as debt repayment or business investment, gone before anyone even knew to look. The bank's investigation confirmed within 2 weeks that the login used for the attempted withdrawal matched an IP address traced back to Mark's home internet connection. It wasn't proof beyond all doubt in a criminal sense, but it was more than enough for Patricia to bring directly into our civil case, and more than enough to make the judge start asking very different questions about Mark's true intentions. When Patricia formally notified Mark's attorney that we had this evidence, something shifted. Mark's lawyer, a young guy named Devin Pratt, who I later learned was fairly new to elder law cases, started sounding noticeably less confident in his communications with Patricia's office. Denise, on the other hand, seemed to panic in a completely different direction. She started calling me again, this time not cold and scripted but frantic, crying, insisting she had nothing to do with the bank thing, that it was all Mark, that she'd only gone along with the guardianship because Mark convinced her it was necessary and she trusted him. I didn't know whether to believe her. Part of me wanted to because some small, stubborn piece of my heart still wanted my sister back, the one who used to paint my nails when we were kids and cried at every single one of my school plays. But another part of me, the part that had spent 2 months building a case file out of betrayal, knew better than to trust anything either of them said anymore without proof. I told her that if she truly wanted to make things right, she should withdraw from the guardianship petition entirely and give a statement to Patricia about what she knew regarding Mark's plans, including the bank login and the origin of Dr. Reeves's evaluation. There was a long pause, then she said she needed to think about it and hung up. I didn't hear from her again for 11 days. During that stretch of silence, Patricia's investigator, a retired police detective named Ray Delgado who now specialized in elder financial abuse cases, dug deeper into Dr. Reeves's background. What he found explained everything. Dr. Reeves wasn't actually a licensed geriatric psychiatrist at all. He held a general practitioner license that had been placed on probationary status 2 years earlier following a state medical board investigation into improper prescribing practices. He had no formal training or certification in geriatric cognitive assessment whatsoever. More damning, Ray discovered that Dr. Reeves had performed at least 4 other similar wellness evaluations over the past 18 months, each one commissioned privately by family members involved in guardianship disputes, each one conveniently concluding that the elderly relative in question lacked capacity, and each one paid for in cash off the books with no formal medical billing on record anywhere. In other words, my brother hadn't found a doctor. He had found a business, a man selling fraudulent medical opinions to families willing to pay for the outcome they wanted, and Mark had apparently been willing to pay. Patricia was almost giddy when she called to tell me, in that specific way lawyers get when they know they've found the piece of evidence that wins a case. She said this wasn't just going to sink the guardianship petition anymore. This was heading toward criminal fraud territory, both for Dr. Reeves and potentially for Mark himself. She filed everything with the court immediately: Ray's investigative report, the bank's fraud findings, Dr. Whitman's records, Dr. Enkemelu's independent evaluation, and a formal request that the judge not only deny the guardianship petition but refer the matter to the district attorney's office for review of possible elder financial abuse and fraud. The hearing was moved up at the judge's own request once she reviewed the emergency filings. She wanted this resolved quickly, and I got the distinct sense from Patricia's read of the situation that the judge was furious about what she was seeing on paper. 2 days before the hearing, Denise finally called me back. She was different this time, quieter, more broken than frantic. She told me she wanted to give a statement. She told me that Mark had, in fact, orchestrated the entire plan from the beginning, that he'd found Dr. Reeves through some online forum for asset protection strategies, that he'd been the one who set up the fake wellness evaluation, forged Dad's signature on some ancillary documents she'd seen briefly, and pressured her into joining because he told her the guardianship would fall apart legally if it named only one sibling, and she'd get a cut of whatever they streamlined from Dad's estate once it was under their control. She said she went along with it because her marriage was falling apart financially, because Chris's car business had collapsed the year before, because she was drowning in debt and scared, and Mark made it sound like they weren't really hurting Dad, just helping him make better decisions a little early. I asked her if she actually believed that, even for a second. She was quiet for a long time, and then she said, very softly, "I think I just wanted to believe it because I needed the money to be true." I didn't forgive her in that moment. I'm still not sure I fully have. But I told her that if she wanted any chance of repairing what was left of her relationship with Dad, she needed to tell the truth in court, completely and without softening Mark's role to protect him. She agreed, and Patricia arranged for her to give a sworn statement the next morning, which became a critical piece of evidence heading into the hearing. The morning of the hearing, I drove Dad to the courthouse myself. He wore his good suit, the navy one he'd worn to my wedding years ago before it fell apart, and he held my hand tightly in the elevator up to the courtroom floor, his fingers trembling slightly, though whether from the Parkinson's or from fear, I honestly couldn't tell. He looked at me before we walked in and said, "I never thought I'd have to prove I'm still myself in a courtroom." I didn't have anything wise to say back to him. I just squeezed his hand and told him I wasn't going anywhere. Mark was already seated at the other table when we walked in, next to Devin Pratt, his lawyer, both of them looking noticeably tense. Denise wasn't seated with them. She sat alone in the gallery, several rows back, having already withdrawn her name from the petition the day before through her own separate attorney. The hearing began with Mark's side presenting their case first. Devin Pratt tried to introduce Dr. Reeves's evaluation as the cornerstone of their argument, but the judge, a sharp-eyed woman named Judge Ferris who had clearly already reviewed our emergency filings, cut him off almost immediately and asked pointed questions about Dr. Reeves's licensing status and the lack of any referral from Dad's actual treating physician. Devin stumbled through an answer that satisfied no one, including from the look on his face himself. Then Patricia called Dr. Whitman to the stand. She testified clearly and confidently about 15 years of consistent medical records, about Dad's most recent checkup 6 weeks before the petition was filed showing no cognitive concerns whatsoever, and about the fact that no one from any evaluation team had ever contacted her office, despite standard medical practice requiring exactly that kind of consultation in legitimate cases. Next came Dr. Nkemelu, whose independent, court-recognized evaluation methodically dismantled every claim in Dr. Reeves's report, point by point, with the kind of calm clinical authority that made the whole courtroom go still. Then Ray Delgado took the stand and laid out his investigative findings on Dr. Reeves, the probation status, the pattern of similar cash-paid evaluations across multiple unrelated guardianship disputes, each one benefiting whichever family member had hired him. I watched Judge Ferris's face harden with every new piece of testimony. By the time Ray finished, she was writing rapidly in her notes, her jaw set in a way that told me she already knew where this was heading. Then came the moment I had been dreading and anticipating in equal measure. Patricia called Denise to the stand. Denise walked up slowly, refusing to look at Mark, her hands shaking as she was sworn in. She told the truth, all of it, exactly the way she'd told me on the phone 2 days earlier, including the detail about Mark forging Dad's signature on ancillary asset transfer documents she had personally witnessed him complete at his kitchen table. Mark's face went white. Devin Pratt tried to object, but Judge Ferris allowed the testimony to continue, noting that Denise's status as a co-petitioner withdrawing her claim made her testimony directly relevant to the credibility of the entire petition. When Denise finished, she looked at Dad for the first time since walking into the courtroom and she said, her voice breaking, "I'm sorry, Dad, I should have never gone along with any of this." Dad didn't say anything back. He just looked at her with an expression I can only describe as grief, the specific grief of watching your child become someone you don't recognize. Then Patricia called Dad himself to the stand, not as a formality, but as the final and most powerful piece of evidence we had. She asked him simple, direct questions about his finances, his medical history, his understanding of what guardianship would mean for his rights, and he answered every single one clearly, with the same steady confidence he'd shown in every evaluation for the past 2 months. Devin Pratt, clearly grasping at anything by that point, tried a line of cross-examination designed to trip Dad up, asking rapid-fire questions about complex financial terminology, hoping to catch him confused or hesitant. Dad looked him dead in the eye and said, "Son, I ran a machine shop floor for 30 years and balanced my own books the whole time without a single audit ever finding a mistake. I think I can handle answering your questions." A few people in the gallery actually laughed, and even Judge Ferris allowed herself a small, tight smile before reminding the room to remain composed. Devin had nothing left after that. He sat back down without asking another question. Judge Ferris didn't take long to deliberate. She said, and I'm paraphrasing only slightly because I was crying too hard to catch every exact word, that this was one of the most troubling guardianship petitions she had reviewed in her career, not because the underlying concern for an aging parent's well-being was necessarily wrong to raise, but because the evidence overwhelmingly suggested this petition had been built not out of genuine concern, but out of a calculated attempt to seize control of a competent man's assets under the false pretense of protecting him. She denied the guardianship petition in full. She ordered that the emergency account freeze remain in place only long enough for the bank's fraud investigation to formally conclude, after which full control would revert entirely and exclusively to Dad. And she stated on the record that she was referring the matter to the district attorney's office for review of potential elder financial abuse and fraud charges against both Mark and Dr. Reeves. Mark sat frozen at the defense table, staring straight ahead, his face somewhere between shock and something that almost looked like fear settling in for the first time. I helped Dad stand up and he was shaking, though this time I knew it wasn't the Parkinson's. He hugged me right there in the courtroom in front of everyone and whispered into my shoulder that he didn't know what he would have done without me. I want to tell you the story ended there in that courtroom with a clean and simple victory. But real life doesn't wrap up that neatly, and what came in the months afterward was its own kind of reckoning that none of us fully expected. The district attorney's office did pursue charges. Dr. Reeves eventually pleaded guilty to multiple counts of medical fraud tied to a string of falsified evaluations, lost his medical license entirely, and was sentenced to a combination of restitution payments and probation, since it turned out he had done this to at least 6 other families before ours, each one just as devastating as our own. Mark's case took longer, dragged through months of legal proceedings, but ultimately the evidence, especially the bank's fraud findings and Denise's testimony, was strong enough that he accepted a plea agreement rather than risk trial. He avoided significant jail time, largely because it was a first offense and the amount actually stolen thanks to the account freeze was technically zero, but he was convicted of attempted financial exploitation of an elder and forgery, left with a permanent criminal record, a mountain of legal debt, and a business that finally, unable to withstand the scandal on top of its existing problems, folded completely within the year. Dad never spoke to Mark again after that hearing. Not out of spite, he told me once quietly on the porch one evening, but because he said some betrayals aren't about anger anymore, they're about grief, and there's no amount of apology that undoes watching your own son try to erase you from your own life while you were still standing right in front of him. Denise's path was different, slower, and more complicated. She spent the better part of a year in therapy, something she'd never done before in her life, working through what she later described to me as the shame of realizing how easily she let desperation talk her into betraying her own father. She wrote Dad a long letter, handwritten, taking full accountability without a single excuse buried inside it. Dad didn't forgive her right away. It took months of small gestures, showing up to help with yard work, driving him to appointments when I couldn't, simply being present without asking for anything in return before he slowly, cautiously let her back into his life. Their relationship today isn't what it once was, and I don't think it ever fully will be, but it's honest now, in a way it maybe never was before. As for me, something shifted permanently in how Dad and I related to each other after all of this. Not long after the guardianship petition was dismissed, he asked me to come with him to Patricia's office, and he sat me down and told me he wanted to update his estate planning documents, this time the right way, with full legal protections in place. He named me as his healthcare proxy and financial power of attorney, not because he doubted his own competency, he made that very clear, but because he said he wanted someone in that role who had already proven, under the worst possible pressure, that she would only ever use that power to protect him, never against him. He also, quietly and without any dramatic announcement, restructured his will. He left the house to me outright, along with the majority of his retirement savings, with smaller specific bequests to Denise's 2 kids, my niece and nephew, held in trust until they turned 25, structured deliberately so the money would go directly to them and never pass through their parents' hands. Mark was named in the will exactly once, receiving $1, a symbolic but unmistakable statement that Dad wanted on permanent legal record. I didn't ask him to do any of that. I told him so more than once. He just looked at me and said that trust isn't something you can fake your way into, and that after everything, he finally understood exactly who in this family had earned his. Sometimes, late at night, I still think about that first Tuesday, the phone call from Mrs. Alvarez about a strange man in a suit, and how close we came to losing everything before we even knew there was a fight happening at all. I think about how quiet betrayal can be in its early stages, how it wears the mask of concern, how it counts on you not paying close enough attention until it's too late to stop it. But I also think about Dad, sitting in that witness chair, steady and clear and completely himself, looking his own son's lawyer dead in the eye without flinching. I think about Dr. Whitman's records and Dr. Nkemelu's careful evaluation and Ray Delgado's relentless digging and Patricia's fierce determination and even Denise's shaking voice finally telling the truth when it mattered most. Family is supposed to be the people who show up for you no matter what. Sometimes it turns out to be something else entirely, something that has to be fought against instead of leaned on. But every once in a while, if you're paying close enough attention, and if you refuse to look away, the truth finds its way to the surface exactly when it needs to. My father is 72 now. He still does the crossword every morning, still in pen, still without a single doubt in his hand. And every single day I get to sit across the table from him, watching him fill in those answers, grateful beyond words that he still gets to be the one holding the pen.